Welcome to Studio CF, the video law blog by the Carlton Fields Law Firm. My name is Joanna Garcia, and I'm a business litigator. Joining me is Scott Pence, a construction and real estate attorney at the firm. The topic for this episode is ACORD Certificates of Insurance. Scott, what is ACORD and what does it do?
Well, ACORD stands for the Association for Cooperative Operations Research and Development. They basically develop standards and forms for the insurance industry, such as certificates of insurance.
For those who may not know, what is a certificate of insurance?
A certificate of insurance generally is a document that summarizes a policyholder's current insurance coverage. It's typically requested by that policyholder in order to provide evidence to another party that it has that insurance in place. The person to whom that certificate is issued is referred to as a certificate holder. And certificate holders often mistakenly believe that they can rely on the information within that insurance certificate much the same way that they might rely on the information within the actual policy.
Why can't a certificate holder rely on a certificate of insurance?
Certificates of insurance contain numerous disclaimers, effectively limiting the certificate holder's ability to rely upon the information within that form. They contain disclaimers that basically say that the certificate is issued as a matter of information only, that if the terms within the certificate of insurance differ from the terms of the policy itself, that the terms of the policy will control and prevail. Generally speaking, a certificate of insurance is merely evidence that the policies identified within it are in force at the time that the certificate is issued. There's no assurances at all that those policies won't be modified or canceled at a later date.
I understand that ACORD updated its certificate forms in 2009. Isn't that right?
That's right, Joanna. And the most significant change relates to the insurer's requirement to provide notice to the certificate holder in the event that any of the policies within the certificate are canceled prior to their expiration date.
So what's the effect of that change, if any?
Well, the new language in the ACORD forms requires that the insurer provide notice to the certificate holder in accordance with the terms of the policy itself. The problem with that is that a typical insurance policy only requires the insurer to provide notice to the primary insured. So there's no adequate protection to the certificate holder in the event that any of the policies are canceled.
To avoid that issue, can the party simply use the prior version of the ACORD form?
Actually, no. Agents are only authorized to use the most recent version of the ACORD forms, and using any older version would be a violation of their licensing agreement with ACORD.
Well, can't the parties just modify an ACORD form?
We see this in practice quite a bit, where the parties will take an ACORD form and remove all the references to ACORD. This raises several concerns. The first concern would be copyright concerns, if the form is substantially similar to the ACORD form. The second concern is that if the modifications to the form go too far and actually are deemed to be an attempt to modify the terms of the underlying policy, then the certificate of insurance in most jurisdictions would have to be submitted to the state and approved as a policy form.
Scott, given the fact that the ACORD form doesn't impose an obligation on the insurance company to provide notice, could the certificate holder contractually require the insured to do so?
Yes, the parties could contractually require the insured to provide notice to the certificate holder, but then you have to rely on the insured to actually comply with that requirement. And in many cases, there may be disincentives for them to do so.
Then is there another solution?
Another solution, Joanna, would be to obtain an endorsement to the insurance policy requiring the insurance company to provide that notice. There are basically two types of endorsements that an insurance company might be willing to provide. The first of which is a blanket endorsement, and the second is called a scheduled endorsement.
Tell us about blanket endorsements.
Under a blanket endorsement, the insurance company agrees to send notice of cancellation to the certificate holder to the extent that the insured has agreed contractually that the insurance company will do so. The blanket endorsement doesn't indicate, however, to whom that notice is to be sent, and so it necessarily relies upon the insured notifying the insurance company that it's entered into a contract with someone to whom that notice needs to be sent. If the insurance company ultimately doesn't find out that the insured has entered into that contract and to whom that it's supposed to send that notice, then the certificate holder will not receive the benefit of that endorsement.
And what about scheduled endorsements?
Well, a scheduled endorsement is much better than a blanket endorsement, because under a scheduled endorsement, the insurance company agrees to add the specific contact information and the name of the certificate holder to the policy itself. So there's no potential breakdown in communication.
Does the certificate holder have the option of requiring periodic updates to the certificate of insurance?
Yes, the parties could agree to do that, but one of the risks associated with that option would be that the policy could potentially be canceled sometime between those scheduled intervals. So a better practice might be that if the parties agree that updates are going to be required, to require those updates in conjunction with obtaining a scheduled endorsement.
So it sounds like certificate holders shouldn't rely exclusively on an ACORD form.
That's exactly right, Joanna. But what certificate holders should be aware of is that they have an array of options available to them to protect their interest.
That brings us to the end of this episode of Studio CF. We hope you found this discussion informative. Please take a moment to browse through our other legal topics and be sure to check back with us each month for new episodes. Thank you for watching.